reply brief, which sort of explicitly says, in that case, sort of the opposite happened. The trial court found that the wife had no need for alimony based solely on her financial affidavit. And the court, and I think it was a 5th District case, said, wait, it's clear that this financial affidavit is not based on the standard of living during the marriage. It's a present-based affidavit. In that case, the wife was living in a one-bedroom apartment with a roommate. It was clear that that was a snapshot in time. That is what financial affidavits are. That is how people are instructed to fill them out. And you can look at my client's financial affidavit and see that. He has, for example, no expense for vacations, no expense for car repairs.
What did he have for rent?
Off the top of my head, I can't recall. I believe it was $2,200, but I don't know that for sure.
And that was the rent from the girlfriend's mother?
That was the rent that was on the lease for that house, yes.
And he prepared?
Correct.
And,
well, that the court...
And that finding is followed by the judge saying he's not credible. He's lied on many occasions.
Correct. Agreed.
I mean, I think there's a relationship between those two paragraphs. The way I took that is the judge said, this guy ain't paying rent. The girlfriend wasn't paying rent to her mother before they hooked up. I don't believe he's paying rent now. And if you take that out of the equation, does the ability to pay alimony go up?
This is why there needs to be these kind of explicit...
It would have been nice to connect the dots, but he's done everything but call your client an unadulterated liar in that judgment. It's hard to give him credibility now and blame the judge for not being a little more concise with his language. And my other question was, because they're kind of mixed together, is the ability to pay the life insurance. Tell me if I'm wrong, but the life insurance was being provided by the employer at no cost to the husband?
Correct.
At least at the time of the hearing?
Correct.
So he wouldn't necessarily have to find an ability to pay the $125, or that he was insurable to pay the $125 until he quit his job and it became an issue, and then he'd have to apply for modification. Or, of course, he could say he has the current ability based upon the employer and leave it go at that, and then put the burden on the other side to ask for life insurance after this became an issue. But right now, it's not on the table as a ripe issue.
So that is the Sikora case. And I will say, full disclosure, Sikora was my case at the trial level and on appeal, and I made that argument and lost on it. Because what happened in Sikora...
on that argument, right?
Well, it's probably too late for that. What happened in Sikora was almost the same thing. The guy had $3 million worth of life insurance presently. He had a clear ability to pay. That insurance cost him, I believe, $3,000 a year. He had thousands of dollars of surplus every month. And this court said, that's really not the analysis. When you're doing an award like this, you have to find a present ability to become insured and a present ability to pay. Essentially...
Why isn't that established by the fact that he was receiving life insurance in the amount that the trial court ordered as a benefit from his current employer? I mean, as I read this record, all that would be required of the husband to comply with that provision of the final judgment is to name the former wife the beneficiary of the benefit.
You're absolutely correct, and that's what I, again, believed would have happened in Sikora. But I think the idea of Sikora is when you award life insurance to secure alimony, you are essentially supposed to be starting from scratch and saying, get a new policy. Now, if what the court meant to do, and it's not actually crystal clear that the court meant to do this, although I think you can infer it, if the court meant to say that life insurance policy you own, give that to her, that's an asset the court is awarding. That is a type of equitable distribution, not an award of insurance.
Was there any rehearing motion to get clarification?
There was not, no.
Okay, so we're speculating at this point.
We are, but my point is we can take one of two paths. One is the court intended him to get new life insurance to cover this, and under that analysis, there needed to be present insurability, and or it was keep the insurance you got, which is an asset.
And what's the standard review? There's a presumption of correctness. So if there's a way to interpret an order, one is presumed correct and one is presumed reversible error, we're supposed to look at the presumption of correctness.
If the court meant to say you have life insurance that you own, give it to your wife, that becomes equitable distribution. That's an asset transferred. There are no findings of the value of that policy. There are no findings in
Right, but
anything to do.
Take the other side, that was meant to secure the alimony if it's such a long-term marriage, because she has ongoing health issues, she had need for ongoing medication, he canceled the work policy, he quit his job the day before, and he brought a $13,000 check to pay the wife the arrearages that he owed for canceling the insurance. Take that as what's going on here.
I still believe that to order somebody to carry the life insurance, you have to make those findings. Now, the argument on the life insurance issue from our perspective is still twofold, and that's the Voda case, which says, yes, and again, it's another second district case, and says, yes, you can award life insurance to protect an alimony award, but it's for special circumstances. It's not supposed to be the default, and the court has to make findings of special circumstances. Here, what the judge did is essentially say, there are special circumstances, the wife needs alimony. That is literally, by definition, true in every alimony case. What's true in every case can't also be special circumstances. Had the judge made those findings, and this is part of the frustration with the fact that the court didn't make these findings. It makes it hard from an appeals perspective to argue that the findings were not supported. For example, going back to the alimony, had the judge said, I'm finding an ability to pay because he doesn't pay rent. Well, I could have come to this court and argued that that was an abuse of discretion. I could have argued that that was a temporary circumstance, that clearly this man needs to pay rent.
Not on this record you couldn't have. I think the evidence quite clearly shows. I think the judge could have rejected the husband's testimony about the rent on one of two bases. Either one, the lack of credibility the court believed he had with respect to the existence of the obligation, or two, the fact that he was providing in-kind services for the rent. So that isn't an argument you really could have made.
I agree it would have been difficult. I still think the husband...
You're at your 6 minutes. I hate to tell you that. So if you want to say 5, you got a minute to keep going.
I'll save 6 unless there's another question on.
For you.
Thank you.
Any objection to saving 6 versus 5? No. Okay.
Good morning, Your Honors. May it please the Court. My name is Kristen Norris. I'm here with Stuart Markman. We're of Kynes, Markman, and Fellman. We represent Mrs. Stevenson. I think the Court has already pointed out these are really two of the most discretionary decisions we put in the hands of our family law judges regarding the amount of alimony and whether to secure that alimony with life insurance. And I think really the two admittedly candid confessions in the husband's brief that there is evidence to support the need and there is evidence to support the ability to pay really sort of close the door on that issue. And the reality is, even if the trial judge credited all of the testimony on the husband's expenses that he was paying, even if you kept in the rent, even if you there was no evidence about him actually paying the student loan, so that wasn't discussed. But even if you credited all that, he had enough of a surplus to meet that payment. And so this is not just his financial affidavit either. I mean, he didn't testify, oh, I also need this, but I haven't been able to pay it. You know, so this is the financial affidavit, the testimony, et cetera. Even if you credited what he said, there was an ability to pay there. I think on the findings, I think the court has fleshed this out quite a bit, but you know, the Crick case, there were basically no findings at all on gross or net income. So what you have here is findings on gross income, findings on net income, findings on the specific amount of need, findings on each of the statutory factors, and the argument that there should be sort of a line by line on the husband's side as to what his real expenses are is just not, it's not covered in the case law. It's descending to details that have not been required at this point in time. There was an express finding of ability to pay.
Could you touch on the special circumstances argument?
Yes.
That he's mentioned?
Right. So the 61.08 basically says you can order any party who is required to pay alimony to purchase or maintain a life insurance to the extent necessary to protect the award. And in Sobelman, the Supreme Court, said that under this statute, you could order such life insurance, the quote was, to protect the financial well-being of the other spouse. And what's developed in the case law as special circumstances test is kind of how it's been named, is that you're looking at whether or not the payor's death would jeopardize the payee's financial well-being, and some of the factors that are looked at: limited earning capacity, age, poor health, lack of assets to draw upon. And so what you see in the case law, if you sort of take the 30,000 foot, is you see cases like Ruberg, millions of dollars in assets, really high alimony awards. So the alimony is a need to maintain the standard of living, but it's not a need maybe in the common sense of the word. Then you have the cases, and I'm probably going to get some of the names wrong, but you have some cases where the spouse can only make $350, and so it's absolutely critical, and it's an abuse of discretion not to grant it there. And then you have this wide swath in the middle, including cases like this, where you have what was a comfortable middle-class lifestyle is now being split in two, and the testimony was the wife was 50s in a profession that most people are out of by 55. Her income alone would be $2,800. $1,500 for the mortgage payment and $600 something for the health insurance was going to eat that up. So there was evidence that she was going to have this need if the husband suddenly died and she couldn't rely on the alimony. And the court found, and I want to say this, he didn't find that she needed the alimony. He found that she was dependent upon the alimony, and I think there's a distinction there. And that, coupled with all the findings with alimony that kind of tie in, gives the court the discretion in this circumstance.
If the husband were to lose the life insurance benefit he gets through the employer, the employer does away with the benefit, husband loses the job, whatever,
right,
would that be a substantial change in circumstances?
I would think it would. It would be a substantial change in circumstance. If through no fault of his own, that life insurance was all of a sudden not available, and there was a changed circumstance, that would be a grounds for modification. And I do want to say that the wording of the judgment is maintain. The wife has shown special circumstances to require the husband to maintain life insurance, was in the findings portion, and then the husband shall carry and maintain and keep in full force and effect. This wasn't an asset transfer. It didn't say turn the whole policy over to the wife. It was just maintain the beneficiary.
What's interesting, Ms. Norris, and for me, I just thought, is there a distinction with the court saying that you shall maintain versus there's a whole litany of cases that you have to acquire life insurance? So I guess in my mind, there may be a distinction in terms of the analysis where if you're required to purchase life insurance, then there's that determination needs to be made by the trial judge in terms of is he capable, is he able to, and all those factors. Here, and which the case law doesn't differentiate that, but if somebody just maintain, you have it, you maintain it, you're not going out of pocket, you're not doing this. So that level of scrutiny, even though it's not delineated at all in the case law,
I think it actually is delineated in the Socorro case. I do think that's kind of where you see the dividing line, because there were two policies in place, but now the judge was saying they were two $1.5 million policies, and the judge was saying, I want you to maintain a $2 million policy. So now we have to look at, or I want you to obtain, it's actually stated in the case. So if the judge is ordering somebody to go obtain something that they do not have, then yes, evidence of insurability, what's that going to cost?
Were the policies in Socorro employment benefits too? I mean, it seems to me there's a difference between life insurance that's provided as a incident to employment and life insurance that your ability even to maintain it could vary depending on, how frequently underwriting happens and stuff like that.
Correct. In Socorro, they were definitely, they seemed to be private pay policies because there was statements about the amount of premiums the husband was currently paying personally. I guess it's possible that was, I'm assuming there were private pay policies. And yes, and I do think the maintain, obtain is an important distinction. And if this were an award above what he said he had available, I think that would be required. But because it was kept within this, this is what he has. And the language in the evidence is maintain. I suppose maybe if we get down the road and he doesn't have it, then what maintain means may become an issue down the road. But there definitely was the evidence and to support this. And, I agree with counsel that this isn't a hard case in that it's not one that, we have some kind of complex legal analysis, but this is the type of hard cases that come before our trial courts every day, where we've got two people of comfortable but relatively modest means, and we're trying to, split it up. And so there's some hard choices to be made. And the judge followed the evidence in this case, supported his conclusions with findings of fact, and there's no abuse of discretion. We'd ask the court to affirm.
Mr. Baseman?
Just to address the life insurance issue again, but I'd like to end on the alimony one. The court's order is that husband shall carry and maintain and keep in full force and effect at all times a life insurance policy for the benefit of the wife with a minimum face amount of $125,000, and then it says upon termination of alimony, that obligation terminates. If the court meant only to require that he carry this work-related insurance policy, it very easily, and I think it's not too much to say, you could have expected that the court would say, as long as this policy remains available through his employer. It doesn't say that. He's obligated to keep this potentially for all time, as it's a permanent alimony award. If he loses...
But why not, given the evidence in this case, isn't that more properly considered a modification issue rather than an issue going to the validity of the provision of the judgment? I mean, clearly here, this provision bears a relationship to the trial evidence, which was life insurance is currently available at no cost to the husband in this amount.
And I think that's an important question, and it's going to tie me back to my final points on alimony, which is, for a modification, you need a starting point. You have to show substantial change. It is not always possible to say what the trial judge 10, 15, 20 years ago was probably thinking was that he meant this. You need to be able to say, these elements have changed. This is why the court should be finding a life insurance policy would cost this much. He has the ability to pay this much. Because then in the future, if that amount changed or if his ability to pay changed, he could explicitly say, this is my substantial change in circumstances. This is why I need a modification. If he moved to modify this on this final judgment, my argument in response to that would be, show me what has changed from the final judgment. And I think it would be very difficult to do that. This is also why these explicit findings need to be made in the alimony context. For example, going back to the rent issue, if the judge had said, husband can afford to pay the alimony of this amount because he shows a surplus of this and he's not paying rent and therefore his surplus is this. That allows the husband to come back later and say, that has substantially changed. I now have to pay rent of this amount. We can now redo that alimony calculation. Without that, with simply speculation as to how the judge calculated, it makes it difficult, if not impossible, to come back and say what has changed. We don't know what the alimony award is based on, so it's impossible to say what has changed. In other words, if he came back and said, now I have to pay rent, the defense to that is, you said you were paying rent at the time. We don't know whether the judge factored that in. We cannot say. And you could do that with every single individual item in this alimony award. Again, what this essentially comes down to, for lack of a better way of putting it, is the alimony is arbitrary. It's absolutely arbitrary. There's no way to know where this $2,800 number comes from. The court clearly found that the wife had a need that exceeded $2,800. So from that perspective, it's not an abuse of discretion, but we have no idea how the court determined that $2,800 was appropriate.
What, if anything, should we make of the fact that your client was carrying temporary payments of, I think, $2,677, which, if I'm right, is a difference of about $133 from what the ultimate permanent alimony award was?
His testimony was that while he was doing that, he was unable to meet his expenses. His testimony, and I know credibility, but his testimony was that that was why he wasn't able to pay rent. His testimony was he was struggling. And that also explains why it is not appropriate for the court to go off his financial affidavit alone, because that affidavit was clearly based on a present analysis while he was paying these expenses. These expenses, this is this would explain why he has nothing for vacation. He has nothing for other things that the wife considered part of the marital standard of living, because he simply couldn't make ends meet during the case itself. And I think that is why it's critical for this analysis to take place. Ultimately, at the end of the day, I understand it's family law, it's abuse of discretion. It's very easy to look at a $2,800 number and say, this is small change.
You've got
This-
about a half a minute to wrap up.
I will, thank you. This is a permanent alimony award. This could easily, these people are 50 years old. This could go on for 20 years. This alimony could be well in excess of $500,000. And it's not just any debt. This is a debt that my client could go to jail for not paying at some point. I don't believe it is too much to ask for a judge in this situation to show his work.
All
I
right,
have
you're out
nothing
of time.
further.
Perfect, thank you.
Thank you.
both.